Good morning from Vienna, good afternoon, good evening, depending on where you are following us from. And welcome to this webinar on the human rights provisions of the International Convention for the Suppression of Acts of Nuclear Terrorism, or ICSANT. My name is Francesca Andrian. I am a crime prevention and criminal justice officer at the Chemical, Biological, Radiological, and Nuclear Terrorism Prevention Program of UNODC's Terrorism Prevention Branch, and I will be moderating this event. This event is part of a webinar series on ICSANT hosted by UNODC within the framework of a project funded by the European Union that promotes the universalization and effective implementation of this convention. And we are very grateful to the EU for their long-standing support to our work in this field. Each webinar of this series analyzes a specific aspect of ICSANT. Today's event, as I mentioned, will focus in particular on the human rights articles of ICSANT. In line with most recent counterterrorism international legal instruments, ICSANT also contains provisions that ensure that states parties' obligations are implemented in accordance with international law and with due respect for human rights. The Convention contains a number of provisions, in fact, that afford human rights protections, which complement the human rights norms that are not enshrined in the Convention itself, yet are applicable to the subjects it covers. We are very privileged to be joined today by a prominent United Nations human rights official and expert in public international law, Professor Ben Saul. Before introducing our expert and giving him the floor, I will provide you with a short overview of ICSANT, of this convention, and I will briefly outline the human rights protections embedded in it. Please bear with me just a few seconds while I share my presentation. So I hope you can all see it.
Yes.
And it's in presentation mode, correct? Okay,
Yes.
I hope it's clearly visible. So to put things in context, ICSANT is one of the 19 international legal instruments against terrorism that UNODC was mandated to promote by the UN General Assembly. This convention was negotiated by an ad hoc committee established by the General Assembly in 1996. Negotiations for this instrument lasted for approximately 10 years and culminated with its adoption in 2005, followed by its entry into force in 2007, 2 years later, when the minimum required number of ratifications was reached. As of today, this convention has 127 states parties, and its depositary is the UN Secretary General. I mentioned earlier UNODC's mandate to promote this convention. This mandate has been reaffirmed and reiterated through successive resolutions adopted by the UN General Assembly. And here in this slide, you have an excerpt from the most recent resolution that was adopted in this regard. So just to give you a brief overview of the key provisions of this convention. ICSANT is primarily an instrument of international criminal law, in that it establishes as criminal offenses certain unlawful and intentional conduct involving radioactive material, devices, or nuclear facilities. These offenses range, for example, from the illicit use or possession of radioactive material or devices to damage to a nuclear facility in a manner which releases or risks the release of radioactive material. States parties to this convention are required, first of all, to criminalize the illicit conduct established by Article 2 of the Convention in their national legislation, and also to establish their jurisdiction over such conduct under a set of predefined circumstances. Additionally, this convention sets forth a very important principle in the field of international criminal law, a principle which is common also to many of the other counterterrorism international legal instruments. The principle extradite or prosecute, also known by the Latin formula audedere aut judicare. This principle basically aims at ensuring that as many states as possible are competent to investigate, prosecute, and adjudicate serious crimes, such as those that fall under the scope of application of this convention, in order to avoid the creation of safe havens and legal loopholes which might be exploited by potential perpetrators. Finally, this convention establishes a number of mechanisms designed to enhance and strengthen international cooperation in criminal matters among its states parties, including, for example, provisions related to extradition, mutual legal assistance, and information exchange. International cooperation is especially important when we talk about nuclear and radiological terrorism, given the transnational nature of the threat posed by these acts. And also in light of the fact that the potential consequences of these crimes will likely transcend boundaries and affect multiple jurisdictions. I would now like to highlight the specific provisions of the convention, which aim at ensuring that its obligations are implemented in accordance with international law and with due respect for human rights. Starting with Article 10. This provision addresses what happens when a suspected offender, an alleged perpetrator, is found in the territory of a state party. The state must, first of all, immediately take the person into custody or otherwise secure their presence and carry out a preliminary inquiry into the facts. The state must also notify other potentially concerned states and also indicate whether it intends to exercise its jurisdiction. However, Article 10 is not just about security measures. In fact, paragraph 3 of this article states that any person detained pursuant to a convention offense, a proceeding launched under the convention, shall be guaranteed certain rights, such as, for example, the right to communicate with or to be visited by a representative of their state of nationality. So even at this very early stage, when the suspect is first detained, the convention clearly embeds human rights safeguards alongside enforcement obligations. Turning to Article 12, this human rights dimension becomes even more explicit. This article establishes that anyone detained or prosecuted under the convention must be treated fairly and humanely at all stages of the proceedings. This includes full respect for due process guarantees, including the right to a fair trial and the broader human rights protections that are afforded by international human rights law. So in a nutshell, this means that the rule of law and fundamental rights should be respected even in cases involving serious crimes, such as those that fall under the scope of application of ICSANT. Moving on to Article 16, this provision introduces a fundamental human rights safeguard within the Convention, based on the so-called non-discrimination principle. This principle ensures that none of the Convention's provisions are applied in a manner that is abusive or discriminatory. In practical terms, this provision entitles a state party to legitimately reject, to decline, a request for extradition or for mutual legal assistance that was submitted by another state party, if the requested state has substantial reasons to believe that the request was submitted for the sole purpose of prosecuting or punishing that person on account of the person's race, religion, nationality, ethnic origin, or political opinion. So Article 16 acts as a critical safeguard against misuse of the Convention. It ensures that efforts to prevent and combat nuclear and radiological terrorism are never used as a pretext for discrimination or for targeting individuals or groups of individuals unfairly. Finally, Article 17 provides another important tool for cooperation, for international cooperation, while at the same time embedding strong human rights protections. This article allows a person who is already detained, who is already in custody, or who is serving a sentence in one state party to be temporarily transferred to another state party. For example, in order to give testimony, to assist with identification, or to help collect or obtain evidence for an investigation or prosecution under the Convention. However, this transfer is strictly conditional. It is subject to a series of prerequisites, including, for example, the free and informed consent of the person to be transferred. This means that the transfer cannot be imposed. It must be voluntary. It also requires the agreement of both states involved, the original state and the receiving state. Additionally, there are some obligations placed on the receiving state, such as the obligation to keep the person transferred in custody, as well as the obligation to return the person to the custody of the original state. Furthermore, no extradition can be requested for the return of the person who was transferred, and this person will continue to receive credit for time served, so that the transfer does not negatively affect his or her sentence. Paragraph 3 of Article 17 introduces another important safeguard to protect the personal liberty of the person transferred, stating that the person cannot be prosecuted or detained or otherwise subjected to restrictions of their personal liberty by the receiving state for acts committed prior to the transfer. So this article shows that even practical operational cooperation measures, such as the transfer of detained persons, need to be framed within strict safeguards, ensuring certainty, legal certainty, consent, protection against abuse, and respect for the individual at every stage of the process. Before concluding, I would like to remind you that all information related to this convention, as well as to UNODC's work to promote ICSANT, can be accessed on our dedicated website, which is a repository of all resources and information on ICSANT. It is regularly updated and it is available in all the 6 UN official languages. I would also like to briefly mention UNODC's efforts to mainstream human rights into all our mandate areas as a cross-cutting pillar, including in our work to prevent and counter terrorism. UNODC integrates a human rights approach, human rights standards, into all aspects of our counter-terrorism related legal advisory services, technical assistance, and capacity building. As states are the primary holders of human rights obligations, we support them to ensure that their counterterrorism measures, such as national policies or legislations, are fully aligned with international human rights and are founded on the rule of law. As mentioned, we apply a human rights-based approach to all our counterterrorism initiatives and programs, to make sure that they are aligned with key obligations and standards set forth in international treaties, both human rights treaties and counterterrorism conventions. And finally, we keep human rights at the forefront of our efforts at every stage, so throughout the entire program cycle, from assessment and design to implementation, monitoring, and evaluation. I would also like to recall 2 publications that we have developed. They both belong to UNODC's counterterrorism legal training curriculum. The first one, Module 4, focuses on human rights and criminal justice responses to terrorism and was developed by UNODC jointly with the Office of the UN High Commissioner for Human Rights. And secondly, Module 6, which provides an overview of the international legal framework against CBRN terrorism, and which includes a chapter also on this convention, on ICSANT. Lastly, just a word to remind you that our work contributes to the achievement of several of the UN Sustainable Development Goals, most notably SDG 16 on peace, justice, and strong institutions. And with this, I conclude my presentation and I'll stop sharing. And without further ado, we will now continue with the keynote speech, which will be delivered by our distinguished expert. Before introducing him and giving him the floor, I would like to note that the format of the webinar does not allow for a Q&A session. But if you have any questions or feedback, please email them to unodc-icsant@un.org. My colleagues will drop the email address in the chat box, and we will make sure to provide our responses by email. With this, I'm very pleased to introduce our guest speaker, Professor Ben Saul, the United Nations Special Rapporteur on the promotion and protection of human rights and fundamental freedoms while countering terrorism, took up his functions on the 1st of November 2023. He is Challis Chair of International Law at the University of Sydney. He has expertise in public international law, particularly counterterrorism law, human rights and refugee law, the law on the use of force, international humanitarian law, international criminal law, and United Nations law. He has published 20 books and hundreds of scholarly and other articles, and been awarded numerous research grants. His research has been used in international and national courts, and he has been involved in over 150 public inquiries. His book, Defining Terrorism in International Law, is the leading work on the topic. Professor Saul has taught law at Oxford, Harvard, The Hague, and Xiamen Academies of International Law, and in Europe and Asia. He has undertaken professional missions or fieldwork in over 35 countries. Mr. Saul has been involved in cases in international, regional, and national courts, including the International Criminal Tribunal for the former Yugoslavia, the Special Tribunal for Lebanon, the Inter-American Court of Human Rights, and the European Court of Human Rights. He has advised or consulted to United Nations and other international bodies, governments, militaries, judiciaries, and NGOs, and delivered technical assistance in developing countries. He co-drafted the UN Model Legislative Provisions on Victims of Terrorism and UNODC's Professional Training Curriculum on Terrorism and International Law. Professor Saul has served on various professional bodies and editorial boards. He has a doctorate in international law from Oxford and honors degrees in arts and law from the University of Sydney. So quite an impressive background, and I promise this was just the abridged version. Professor Saul, we are very pleased to have you with us today. The floor is yours.
Thanks so much, Francesca, and good evening from Sydney, everybody. I'm delighted to take part in this important event to discuss the protection of human rights under the Nuclear Terrorism Convention. And I acknowledge the great work of UNODC in promoting implementation of the convention over many years with the support of the European Union. I think this convention is particularly important given the growing risks of nuclear proliferation and potential diversion, as well as the breakdown in some ways of the taboo on attacking nuclear facilities, as we've seen in places like Ukraine and Iran in recent years. I'm the UN Special Rapporteur on Human Rights and Counterterrorism, so my job is to assist member states to implement their human rights obligations while countering terrorism. And obviously the 19 international counterterrorism instruments since the late 1960s are particularly important planks in the global counterterrorism regime. When they were first adopted, starting with the Aviation Safety Conventions, little attention was given to expressly protecting human rights under these conventions. And this was really because the instruments were drafted by technical experts in areas which were highly specialized, like aviation and maritime, and then nuclear safety. They were often drafted in expert technical bodies like the International Maritime Organization and the International Civil Aviation Organization. And this was a time in the 60s and the 70s before the two major international human rights covenants of 1966 had entered into force 10 years later in 1976. So countries were still really in the early days of adopting and implementing their human rights obligations after the Second World War. Now, in the half century or so since, as human rights gained greater traction internationally and domestically, the counterterrorism instruments came to pay more attention to human rights, particularly in this so-called new generation of conventions since 1997. So there are 19 in total, but since 1997, around 6 have been adopted, including the Nuclear Terrorism Convention, the Terrorist Bombings Convention, and the Terrorist Financing Convention, as well as some instruments updating the earlier civil and maritime aviation safety conventions. Now, all of the instruments, regardless of whether they were early or more recent, still have to be applied and interpreted consistently with member states' existing international law obligations. And that includes human rights, humanitarian law, and refugee law. Nothing in the conventions seeks to modify or somehow override or contract out of those fundamental obligations under international law. And in the last couple of decades, the General Assembly, the Security Council, the Human Rights Council have all consistently affirmed that states must respect human rights while countering terrorism. And this means including when implementing the various conventions. This is not just a legal obligation, it's a moral imperative. And it's also essential to not only public legitimacy, but the effectiveness of counterterrorism operations as well. Because by following due process and not torturing suspects and respecting the right to privacy and limitations on searches and seizures, all of this ensures the integrity of investigations and prosecutions. It makes sure convictions are sound and that you get the right person and that you're not wasting scarce law enforcement resources chasing people who are not actually genuinely criminal suspects. All of this also facilitates justice for the victims of terrorist acts and prevents innocent people being wrongly accused or convicted. Now, the offences under the Nuclear Terrorism Convention and its obligations of prevention, suppression, and cooperation all play an important role in protecting human rights. They protect the right to life, the right to public health, and to security of person. So the convention helps states in a way to fulfill their human rights obligations, to diligently take all feasible measures to prevent foreseeable threats to life, including where this could arise from the risks involved in nuclear material or the misuse of nuclear material or facilities. Indeed, Article 7 of the Convention requires states to cooperate to take all practical measures, including changing national law where necessary, to prevent and counter preparations in their territories for the commission of nuclear terrorist offences, either in their territories or outside their territories. So this is in part a human rights obligation. It's also an obligation which ensures respect for the sovereignty of other states and prevents interference in public safety in other countries. Now, the Convention's offences carefully and precisely drafted, including in relation to their physical conduct elements, their mental or mens rea elements. And the drafting benefited from relevant experts from many of the world's legal systems, and it reflects a fair compromise between the different legal orders. The offences broadly comply with the requirement of legality under Article 15 of the International Covenant on Civil and Political Rights, which is a principle against retrospective criminal punishment, a principle which requires that offences must be defined with sufficient clarity and certainty and specificity so that people can know in advance what the scope of their criminal liability is. So the offences avoid the problem of vague and overbroad terrorism offences, which are found, unfortunately, in too many national and some regional counterterrorism laws, where terrorism is sometimes defined much more generally rather than tackling specific types of physical conduct. And those kinds of overbroad, vague offences are prone to abuse. They can result in infringements of fundamental rights, including liberty and freedoms of expression, association, assembly, and political participation. The convention also, I think, has a particular kind of legitimacy as a counterterrorism instrument because it was negotiated through a process of participatory and inclusive treaty making under the universal authority of the General Assembly, unlike some other ways that counterterrorism law is sometimes made, for example, through more exclusive and closed off and less transparent Security Council legislation against terrorism, where in the last 25 years, sometimes the Security Council has required countries to do things, but not given sufficient direction to countries about precisely how they should go about that in a manner which complies with human rights. So famously or infamously, the Security Council required all countries to criminalize terrorist acts, but didn't define terrorist acts. And I think many people recognize the problem of what is really only 15 countries, and 5 of them, the permanent members, have a particular influence on the Council, a small group of countries purporting to direct states to adopt legislation when the international community is made up of 193 member states, not only 15 who happen to sit on the Security Council. So these conventions, I think, do have a particular legitimacy. The same Article 6, I would mention, takes things a little bit further because although the convention establishes offences relating to nuclear material and facilities, Article 6 not only requires states to criminalise those conventions, but also offers the option to states to criminalise them as part of their terrorism offences. So it's a duty to criminalise, in particular, whether intended or calculated to provoke a state of terror in the general public or a group of persons or particular persons. So at a minimum, the offences of misusing, etc., nuclear material must be criminalised, but they can also be criminalised in a way which connects them with a more specific terrorism offence. And that element, by the way, of provoking a state of terror has a very old history in international law. Actually, it stems right back to the League of Nations Convention Against Terrorism in 1937. It's also an element which has been supported by the General Assembly in its 1994 Declaration on Measures to Eliminate International Terrorism, and Security Council Resolution 1566 also uses that formulation. So it's one which has quite a lot of political support and consensus. Now, Article 6 also mentions, like the General Assembly and Security Council resolutions, that the offences under the Convention are under no circumstances justifiable by any motive, essentially. So it goes on to talk about political, philosophical, ideological, racial, ethnic, religious, or other similar nature, making the point that terrorism offences, nuclear safety offences are not ones which can ever be justified by any cause, no matter how legitimate that cause might seem to some. If you're a country exercising national self-defense, you can't commit nuclear terrorism. If you're a liberation movement, you can't commit nuclear terrorism. If you're an environmental group, and so on. It's a blanket prohibition regardless of causes. Now, just to address some of the key human rights provisions in the convention, as Francesca mentioned, Article 12 of the convention is the so-called fair treatment provision. So anyone in custody or against whom other measures are taken has to receive fair treatment. This clause goes way back, actually, to the very early aviation safety conventions in the 1970s. It's been gradually strengthened over time. Originally, it only applied to criminal and extradition proceedings. Now it, of course, in addition, applies to all measures under the convention. So that includes investigations prior to arrest or any criminal process. It includes seizures and searches of evidence prior to the initiation of criminal process. It applies to foreign inquiries concerning information or extradition inquiries before a formal request has been received. And it could also cover any of the measures states take in fulfilling their duty to prevent offences under the convention. So that could include law enforcement, security intelligence, information sharing, exchange, technical cooperation, etc., all of which could impinge on individual rights in some way. Now, what does fair treatment mean? It means more than just being nice to people. It has a very specific legal meaning. It's not spelled out in the conventions. Fair treatment is a very simple phrase used, but in the drafting of the conventions, it is understood to refer back to the more detailed standards under international human rights law. So this is a point made by the International Law Commission when this clause was first drafted back in the 1970s. It certainly includes all of the guarantees of a fair trial under Article 14 of the International Covenant on Civil and Political Rights. It includes the prohibition on retrospective punishment under Article 15. Since 1997, the conventions have added that fair treatment includes specifically under international human rights law. So, of course, that means anything that's relevant under the ICCPR. But it could also include relevant provisions of other instruments. So, for example, the specialized conventions on prohibiting torture or other ill treatment, the rights of women and children, persons with disability, all of which could be relevant, for example, in detention situations and the way that people may need to be treated and the conditions of detention. So it's not just fair trial, it's also freedom from torture and cruel, inhuman, degrading treatment, humane and dignified conditions of detention under Article 10 of the ICCPR, the right to privacy under Article 17 and personal data protection in relation to information sharing, mutual legal assistance, searches and seizures of documents and premises. Now, because the convention also, of course, deals with extradition, fair treatment also necessarily covers human rights guarantees in expulsion processes concerning not only nationals, but where states permit the extradition of nationals, but also foreigners, aliens. So Article 13 of the ICCPR requires due process in the expulsion of foreigners, and that includes extradition. Due process in that context includes a decision reached in accordance with law, not just a discretionary executive or political act, a right to submit reasons against the expulsion or the extradition, reviewed by an independent authority, and legal representation. It also includes the prohibition under customary international law of arbitrary expulsion of foreigners, which goes a little bit further than the ICCPR in some respects. And then, furthermore, it obviously includes the prohibition on return or refoulement to a risk of serious human rights violations in another country, whether because there's a risk of torture or persecution or arbitrary deprivation of life. There are a range of reasons why a person may not be able to be lawfully returned under international law. Now, a limitation of these counterterrorism conventions, I would say, is that none of this is spelled out. As I mentioned, it's just a very brief reference to fair treatment and human rights. And it kind of operates by renvoi to all of those other regimes, and the hope that states will identify and apply, the right relevant human rights standards in extradition. So, the drafters certainly could have been more express and spelled out some of those protections or safeguards in a bit more detail. But I do think it's, reasonably clear what would be the relevant human rights standards applicable to extradition, mutual assistance, detention, criminal investigations, searches and seizures, etc. Now, apart from human rights law, I think fair treatment also goes beyond to encompass some other parts of international law as well. So here I'd just draw your attention to the law on consular relations and diplomatic protection. So the right to visit and assist and protect nationals at risk of human rights violations in other countries, including in detention. There are lots of bilateral and multilateral legal standards on extradition and mutual assistance, which go beyond simple non-refoulement standards. I mentioned refugee law already, but also international humanitarian law could be relevant in situations of armed conflict where offences in certain circumstances could be relevant. Now, on top of fair treatment, the convention tops that up by also providing that individuals enjoy all the rights and guarantees under the law of the state in which the person is present. In other words, if national law sets higher standards than human rights law, people involved in these criminal justice processes get the advantage of those higher standards under national law. And I think it's important to remember that human rights law is a floor, not a ceiling. It sets minimum standards, and hopefully many countries will operate their criminal justice systems at a standard of higher levels of protection for criminal suspects than the bare minimum of human rights law, which is, don't torture. That's not a particularly demanding standard. It's a pretty basic standard, and you can expect that many countries will want to do better and protect nationals, foreigners in criminal justice to a higher level. Now, although I've said nothing in the conventions overrides human rights law, so reference to fair treatment, in a way, technically is irrelevant because all of a country's human rights obligations apply anyway in the background. Why it can be practically particularly relevant, though, under the convention, is that the convention, like many of the counterterrorism conventions, does have a dispute resolution clause or a dispute settlement clause in Article 23. And that clause can trigger the jurisdiction of the International Court of Justice where there are disputes over the interpretation or application of the convention. In other words, you could bring an interstate human rights claim before the International Court on the basis of the convention, when otherwise it's often highly likely that there would not be that kind of jurisdiction before the court. Why? Well, because states just haven't consented to human rights adjudicative jurisdiction of the International Court of Justice in many cases. As you know, you've got consent to the International Court's jurisdiction. Many states either haven't done that at all. In fact, a majority of states haven't done that at all. Or if they have done it, it sometimes doesn't extend to human rights cases. And there are no equivalent human rights dispute resolution clauses under the human rights conventions themselves. So this can be a particularly important trigger for binding states to their obligations. And we have seen, I should say, in recent years, an increasing number of cases under transnational criminal cooperation treaties being brought before the International Court of Justice, including under the Terrorist Financing Convention. There's been a case, the Genocide Convention. There are a number of these cases that where the court has been increasingly used. What else under the convention? So moving beyond fair treatment, I would alert you to provisions on consular rights. So have a look at Article 10, which preserves a number of those rights I mentioned earlier. That is a person's right to communicate with their state of nationality or some other state that can protect them. I mean, that might be relevant for stateless persons, for example. This, of course, enables a kind of supervision by a foreign state to ensure that one of their nationals is being treated well throughout the criminal justice process. There's also provision for the International Committee of the Red Cross to provide a kind of substitute consular role in certain cases. The third provision I'd alert you to is what we call the non-discrimination clause in Article 16. And as Francesca mentioned, this is one which allows states not to extradite or provide mutual legal assistance if they have substantial grounds for believing that discrimination would be involved. In other words, it would involve punishment or prosecution or some other prejudice on discriminatory grounds. So this is an important human rights provision. It's weaker than I and some other human rights people would like, because it's really it allows states a discretion to refuse cooperation, but it doesn't mandate the refusal of cooperation. And that's quite different to the Hostages Convention of 1979, which does take a stronger position and requires states to refuse cooperation. Again, this is somewhat symbolic. I mean, it's important that it's there, but at the same time, because nothing in the convention requires extradition, therefore states are not in any way being compelled to extradite in violation of the prohibition on discriminatory treatment. I mean, as you know, the convention operates according to a prosecute or extradite regime. You can freely choose not to extradite, in which case you have to prosecute. But there's no compulsion to extradite. So states are free to refuse on the non-discrimination ground anyway. This is quite common in extradition law and mutual assistance law. But I think what's lacking here, and what perhaps a future generation of conventions or amendments down the track, it would be good to see, is an explicit requirement under all of these conventions that a person must not be extradited in violation of the international legal obligation of non-refoulement. In other words, non-refoulement is an obligation under human rights law and refugee law. It's absolute in some situations, so you can never extradite a person lawfully to a risk of torture or arbitrary deprivation of life or enforced disappearance. There are some other circumstances as well you might put in there. But unfortunately, none of these conventions, and it's not just the terrorism conventions. I mean, this is common across the drug conventions, organized crime conventions, etc. Unfortunately, non-refoulement is not as well reflected in the conventions as it could be. Also, just a side note, the convention mentions certain prohibited grounds of discrimination. But you could also expand them, I think, to encompass the wider range of prohibited grounds under international human rights law. So the convention refers to discrimination on the basis of race, religion, nationality, ethnic origin, or political opinion. But it doesn't talk about all of the many other grounds on which discrimination based on identity or permanent characteristics is often based. So color, language, opinion, social origin, property, birth, social group, other status, minority status, age, disability, marital status, place of residence, sexual orientation, etc., gender, etc. There are obviously lots of ways states can illegally target people because of their identity. And unfortunately, in my job as special rapporteur, we see this too often. Counterterrorism law is habitually used to target civil society, human rights defenders, marginalized groups that certain governments don't like. So these are real world risks. Now, a couple of other things I'd briefly mention. The conventions don't mention the other common grounds for refusing extradition or mutual assistance that you typically find in national and bilateral and regional extradition law. So grounds like double jeopardy, double criminality, injustice, humanitarian considerations. These are all ways of protecting human rights as well. And I would encourage member states in implementation to also give attention to those protective grounds when thinking about refusing extradition or mutual assistance as well. Now, our time is short, so I'll just very briefly mention a final few provisions. Article 17 requires the consent of any detainee or prisoner whose presence may be sought in another country to provide evidence in a legal proceeding, and they get immunity from prosecution for providing that witness testimony. So those are very positive safeguards. There are Article 18 concerns the application of international health and safety standards of the Atomic Energy Agency in the handling of seized or otherwise taken nuclear material. So that's a positive thing from a labor law and health and safety, safe and healthy work conditions standpoint as well. There is a provision, Article 4, which is a kind of savings clause, talks about nothing in the convention affecting anything else under international law, including the UN Charter and humanitarian law. That's a little bit cosmetic because nothing in the convention that I can see does interfere in anything else under international law. So it's not a problematic convention in that sense. But I think it does give a little bit of comfort if you think about the possibility, for example, of states illegally using force or aggression on the pretext of countering nuclear threats or nuclear terrorist threats. These are not remote possibilities in the world that we live in. So I think this is affirming, combating nuclear terrorism is not an excuse for violating the prohibition on the use of force or sovereignty or the obligation of non-intervention and so on and so forth. Finally, there's a carve out for activities of armed forces in armed conflict governed by humanitarian law, as well as activities of state military forces in peacetime, which could include certain public emergency operations to combat terrorist threats to nuclear material or hostage type situations at nuclear facilities, etc. Be clear, this is not saying militaries have impunity for illegally killing people when they try to combat threats to nuclear safety. It's just saying that the Nuclear Terrorism Convention is not the right legal framework to apply to that. Humanitarian law still applies if it's an armed conflict. Human rights law still applies if states are going about extrajudicially killing people outside a use of force paradigm in violation of the right to life. There's still the usual obligations to prosecute state officials for illegal conduct and provide remedies and accountability to victims. So look, I think that's an overview of the main provisions. So I think some many positive developments on the human rights side in the convention. Could do better in some respects, but nothing in the convention detracts from the freestanding human rights and humanitarian law and refugee law obligations of states, which should be implemented fully alongside implementation of the convention's provisions. So thanks very much. I'll stop there and throw back to you, Francesca.
Thank you very much, Professor Sol, for this comprehensive overview and analysis of the human rights provisions of the Convention. I'm mindful of time, but maybe we can still take a few minutes because I would like to pose a couple of questions to further dissect some aspects or some specific provisions of ICSANT. First of all, there might be an inherent tension, which is common also to other counterterrorism instruments, between the Convention's security objectives on the one hand and states' obligations under international human rights law on the other hand, that states have to reconcile when implementing ICSANT. In particular, as states strengthen preventive measures against nuclear terrorism and related crimes, in your view, what risks exist that emergency powers or surveillance measures could disproportionately affect certain groups or undermine fundamental rights? In other terms, what do you see as the most significant human rights challenges in implementing ICSANT? And do you think that the Convention contains sufficient safeguards against abuse?
Yeah, it's a great question, Francesca, and I'd emphasize that whatever measures of prevention or suppression or response after an incident that member states take, they always have to respect their human rights obligations. International human rights law already accommodates the need to respond to even the most extreme security risks. States can lawfully limit certain rights where that's necessary and proportionate to do so. In extreme circumstances, there's the possibility of suspending certain rights through derogation in public emergencies, as long as you meet the requirements of derogation. So remember, human rights laws were drafted by the states that emerged from the Second World War, a war that killed, we think, 80 million people. They knew a thing or two about extreme emergencies and security threats, and they created a balance within human rights. So no matter what you do, you can safely address these security risks while also respecting your human rights obligations. Particular risks I'm seeing, of course, are the use of new technologies in surveillance, threatening privacy and other rights, including through the application of artificial intelligence, facial recognition software, and these, of course, bring abuses of discriminatory profiling or targeting against certain groups in society, whether that's based on religion or nationality, or targeting civil society and human rights defenders. We're also seeing an increase in administrative measures. So outside the criminal justice system, restrictions on people's rights or movement, administrative security detention. My last report to the General Assembly was all about how you can use administrative security measures outside the criminal justice system, but you've got to do that in a way which respects human rights, due process, judicial safeguards, etc. So they have to be very carefully crafted as well.
Thank you, Professor. And maybe we have time for one more question. Moving back to some specific provisions of the convention. We talked extensively of the human rights related provisions, but there's also another provision that has some bearing on human rights obligations, which is the criminalization provision of ICSANT, Article 2. Just to recall for the benefit of our audience, Article 2 criminalizes a range of offenses involving radioactive material, devices, or nuclear facilities, including ancillary offenses. And additionally, as you also mentioned, Article 6 requires states to ensure that these acts are criminalized under domestic law, particularly when they are intended to provoke a state of terror. Now, a recurring issue in counterterrorism is the overbroad domestic definition of terrorism, which states sometimes might use to crack down on political dissidents, environmental activists, or whistleblowers, just to name a few. In your view, does the specific wording of Articles 2 and 6 of ICSANT provide enough precision to prevent states from abusing domestic implementation, for example, to criminalize protected speech or legitimate protest?
Yeah, it's a great question, and of course there is no accepted binding international legal definition of terrorism, and this has been a cause of a lot of human rights violations over the years. As some states have adopted definitions which are too broad, don't satisfy legality, impinge on fundamental rights. So this element of provoking a state of terror, as I mentioned, has quite a bit of support behind it from multilateral bodies, but by itself, of course, it's not enough. I mean, it doesn't give you the full description or content of what terrorism is, and for that you have to go a bit further. I'd encourage states to take a look at the general definition in the Terrorist Financing Convention, Resolution 1566 of the Security Council. And just in March this year, my report to the Human Rights Council updates my own mandate's model definition of terrorism. And we present a definition which we think is human rights compliant while also effective in countering terrorism. And it goes like this: serious criminal acts which intentionally kill or inflict serious bodily injury done to either provoke a state of terror / intimidate a population, or to compel or coerce a government to do or refrain from doing something. In addition, all of that has to be done for a political or ideological purpose, because the distinguishing feature of terrorism is that it is essentially political violence, not like organized crime or other personal or private violence. In addition, we suggest some exceptions to the definition so that you don't, for example, criminalize legitimate acts of protest in a democratic society, or you don't criminalize the provision of impartial humanitarian aid in armed conflict. And we also have a carve out for armed conflict more generally along the lines of the provision in the Nuclear Terrorism Convention itself, because I do think it's useful to leave violence in armed conflict largely to humanitarian law. So if people kill civilians, that's a war crime. You don't need terrorism law on top of that. And applying terrorism law in armed conflict tends to have some negative consequences for compliance with humanitarian law by armed groups, impinging on humanitarian action, impinging on peacemaking and the ability of societies to reconcile post-conflict as well. So treating terrorism largely as a peacetime crime and everything in war under humanitarian law, I think is largely a better way to go.
Thank you very much. And I'm mindful of time, and I also know it's getting late in Australia. So this brings us to the end of this event. I would like, first of all, to thank Professor Saul for sharing with us his expertise and shedding light on a crucial aspect of the convention, which helped us better understand how this international legal instrument is designed to prevent and suppress nuclear and radiological crimes, while at the same time ensuring that these efforts respect the fundamental principles of human rights and uphold the rule of law. Allow me to recall before closing that, as stated by the UN Global Counterterrorism Strategy, and also reiterated through multiple resolutions adopted by the UN General Assembly and Security Council, effective counterterrorism measures and the protection of human rights are not conflicting goals, but rather they are complementary and mutually reinforcing. So in other terms, respect for human rights and fundamental freedoms must be an essential element of any effective counterterrorism strategy. We hope we have been able to demonstrate this today with this webinar. ICSANT is an essential instrument that forms the backbone of our efforts to combat terrorism globally. It helps states to prevent and suppress nuclear terrorism and related crimes, while ensuring that the fundamental principles of human rights remain at the core of their efforts. I would also like to thank the audience for joining us today. We welcome your feedback and any questions or comments that you can forward to us by email, and we will make sure to share them with Professor Saul. And lastly, I would like to reiterate our appreciation to the European Union for its financial support to UNODC, which made today's event possible. Before concluding, I'd like to remind you that our next event of this webinar series, the last webinar of the series, in fact, will take place next week on Monday, the 22nd of June, and we'll explore yet another topic. We will be discussing the jurisdictional aspects of ICSANT. So I encourage all of you to join the next webinar as well, and you can find the registration link in the chat box. We hope to see you at next Monday's event. And with this, I close the webinar. And thank you very much and have a nice rest of the day. Thank you.